We thank you so much for watching Voices of the Bar, where the legal world speaks. And today we want to discuss the postal rule. Why is the postal rule important? We are going to also discuss the case of Adam versus Lindesel, being the first English case that established the rule of postal rule. And in this case, we shall go deep into the facts of the case, the issue at court, and we shall also discuss the ratio decidendi of this case, and then we shall appreciate the importance. Why do we have the postal rule under the contract law? This is Voices of the Bar, where the legal world speaks. We ask you to subscribe, to share and like our videos. Don't watch minus subscribing. Hit the subscription button and you follow us. Keep the comments coming. We shall be able to give you the answers to all your law questions that you want to put to us. We run two channels, Law School Made Easy and Voices of the Bar. We ask you to subscribe on both channels. When you look up for a video on Law School Made Easy and you don't see it, that video is on Voices of the Bar. Check it out there. If you check Voices of the Bar and you can't find the video, kindly check on Law School Made Easy. Subscribe to both channels. Let's straight go into the postal rule. Let's begin with the case of Adam versus Lindesel before I put you to the postal rule, because this principle was established in this case. So let's go to the facts of the case of Adam versus Lindesel. Lindesel, who is now the defendant, wanted to sell his wool to Adam. So Lindesel, the defendant in this case, wrote to Adam asking him if he would be able to buy his wool. He put up an offer to Adam to buy his wool. Now, he wrote this letter on the 2nd of September. Of course, he expected he would get a feedback by 7th. So he did not get a feedback. So when he sent the letter, he wrongly addressed the letter, and it took long to reach Adam. So the letter reached Adam on the 5th of September. So that is when the letter reached Adam. Remember, we said that he wrongly addressed the letter when he decided to use post, and he told him to communicate via post. So Lindesel chose the medium of communication, which was by post. So when he sent his letter on the 2nd, he wrongly addressed it, and the letter took long to reach Adam. So when the letter reached Adam on the 5th, Adam replied and he posted the letter on the 9th. So the letter on the 7th, the letter reached Lindesel on the 9th. So when the letter reached on the 9th, on the 8th, Lindesel had sold the wool to someone else. I want to repeat these facts for you. Lindesel, the defendant, wanted to sell his wool to Adam. He gave Adam an offer and he wrote to him on the 2nd, suggesting that Adam would respond through post. So Lindesel wrongly addressed the letter, and the letter only reached Adam on the 5th. When Adam got the letter, he responded and he posted the letter on the 7th. He posted it on the post, and the letter reached Lindesel because in the letter Adam had indicated that he had accepted to buy the wool. So when he posted the letter, took over 2 days, and on the 9th, the letter reached Lindisell. But when the letter reached Lindisell on the 9th, Lindisell had sold the wool on the 8th, because he expected Adam would respond to him by 7th. Now, Adam brings up a case in court. That's why we have Adam versus Lindisell. Now, Adam is saying that when he posted the letter on the post, he had accepted. They had a contract. So the issue before court was whether Adam's posting the letter at the post made a contract between Lindisell and Adam. So this was the issue that court now was addressing. Now, in determining this case, court held in favor of Adam, the plaintiff. And the court was of the view that the moment Adam posted his response, there was a contract. It doesn't matter whether you, the offerer, you have received the letter or you have not received the letter. For as long as Adam posted it, his response, that I have accepted, then the two were in contract. Why is this so? The ratio decision of this case, court now suggested and said that the moment the offerer, Lindisell, suggests the mode of acceptance, that mode must be accepted in that way. That the duty is on the offerer. If the offerer chooses to use mail and he says acceptance would only be if you also use mail, then if you use any other form, that will not be acceptance. So the moment the offerer suggests a medium of acceptance, a form in which one should accept, a form in which they should communicate, then the offerer must bear the consequences of that form that he had decided. I'll give an example. If Adam posts his letter as acceptance, and then the post office gets issue, they get delays, their cars break down, the problem is not on Adam. The problem is on the post and Lindisell, the person who decided to use post. When you choose post, you must bear all the consequences, because it is you who chose to use post. The assumption is there are very many other formats. So if you choose that, you bear all the consequences. That was the reasoning of court. That Lindisell decided to use post, he should bear all the consequences. And therefore, the postal rule suggests that the moment the acceptor, the offeree, posts their acceptance on the post, you have entered the contract. It doesn't matter whether you have received or not. Whichever time you receive, you are in a contract, because you chose that mode. If you look at section 3 of the Contract Act, clause 2, it suggests that communication of an acceptance is complete as against the offerer when it is put in the course of transmission to him or her so as to be out of the power of the acceptor. This is one form how acceptance is complete. That the moment you put it in the course of transmission to go to the offerer's side, there has been acceptance. So that is the postal rule. So you cannot discuss postal rule and you don't bring out section 3, clause 2, subsection 2, section 4, subsection 2 of the Contracts Act. Section 4, subsection 2 of the Contracts Act. That communication is complete when it is out of the offeree and it is now going to the offerer. Then that way you have communicated, and that is the postal rule. The moment you post at the poster, you are in a contract, no more, no less. So the contract is made at the point when you put your acceptance letter on the post. Now note, if the offerer suggests means in which you should accept and you accept in other means, there is no contract. If the offerer says your acceptance must be by mail and then you respond by post, there is no contract. But if he says that your acceptance must be by mail and you email, the moment you email, what happens in between there, how it reaches, where there is network issues, for as long as you mail, the two of you are in a contract. That is the postal rule. The moment the offerer indicates the means of communication, you must follow that. Failure to follow that, there is no contract. And that is the postal rule, the case of Adam versus Lindesel. We thank you so much for watching Voices of the Bar, where the legal world speaks. Subscribe, share, like our videos. Thank you. Until next time. Cheers.